Hi everyone, my name's Tom Cobbin and I'm a solicitor, a principal solicitor at Beryl and Watson Lawyers, and I'm just going to talk to you briefly in this webinar about multiple sclerosis and employment. A lot of people diagnosed with MS have questions about their employment and how the MS might impact on the employment, and this webinar will cover those general questions that we often get. So firstly, a little bit more about us. You'll see that we're a leading plaintiff-based superannuation and insurance law firm. So employment law is not our bread and butter, so to speak, but we do help people often with insurance claims relating to injury or illness, which means that we are expert in helping people with the onset of a chronic illness, particularly, or certainly MS included in that. And out of that, we've developed skill sets in other areas to provide a more holistic service to our clients. So employment is one area that we've gathered an underlying understanding of how the MS and employment interact. And we've been doing this for a long time, so we've picked up a few skills along the way. So we'll talk about multiple sclerosis and employment. And as I've sort of alluded to already, many people that are diagnosed with MS get their diagnosis within their working life. I'm not sure of the stats, but I see, at least anecdotally, I see a lot of people diagnosed during their working years. And the diagnosis is itself a little bit of a mixed bag in terms of how it impacts on people's overall health and in turn their employment. We see some people with a diagnosis of MS based off a single attack or a single relapse, which ultimately doesn't have ongoing consequences with treatment, and people are able to manage that disease reasonably well throughout their working life and only need to make minor, if any, changes to their employment. However, at the other end of the spectrum, we see people who have multiple relapses or a degenerative or a progressive illness onset, and those people are much more affected from a general health perspective and also much more effective, therefore, from an employment perspective. And so I just want to stress that we understand that a diagnosis of MS doesn't mean no work at all. And many people, indeed many people that we've helped, have been able to continue to successfully work and have a fulfilling vocation, a fulfilling career, despite the diagnosis of MS. And so much of what we will talk about today is general in nature, and oftentimes you'll hear a bit of a lawyer's answer. You'll hear a little bit of it depends, and that's, I think, important to understand that it depends in terms of the illness itself and how it manifests for you. Also depends with respect to the work that you are doing. The most common thing that we're asked when someone is first diagnosed with MS is, do I need to tell the employer? And I think the answer is usually no. Usually you don't have to tell them. There are exceptions, and indeed telling them may be something that you do want to do because you may have a supportive employer that's prepared to help you through the diagnosis and similarly give you time away from work in the way that is needed, if needed, and similarly accommodate your illness. So a conversation with your employer is often a good thing to do, but it's not something that you have to do. There's nothing in most employment contracts that we've seen. There's nothing in there that says they need to disclose the MS just because of its diagnosis or any other illness or disease for that matter. Similarly, no EBA that I know of, enterprise bargaining agreement, or any other industrial instrument says that MS or any other condition needs to be diagnosed on diagnosis. However, as set out on that slide, the exception to the rule that you don't need to disclose is where the symptoms of your MS, rather than the MS itself, cause an occupational health and safety risk to you or others in the workplace. And that's an important point, which we're going to discuss a little bit. So as you may have been experienced already, or you may just know from generally working, some employers or prospective employers will ask you whether or not ask you a series of health questions or even ask you to undergo a medical examination with a doctor. And this sometimes will reveal the diagnosis or the presence of a condition like MS. Sometimes the questionnaires are worded in such a way that it's possible to not disclose the MS without being dishonest or lying or being misleading. However, oftentimes you may be asked directly about illnesses or injuries, and if you don't answer that question or if you answer it incorrectly, then that could lead to consequences for you later on during your employment, so it could jeopardize your employment in the future if it's found, if your employer finds out, but not always. I mean, still, even in that circumstance, we think that the employer would need to have reasonable grounds uh, uh, that you can't do your job, and I'll get into that in a moment, in order to terminate your employment, even in face of you having not disclosed the illness when directly asked. So um, I think it's important to think about things really carefully when the question of, do I disclose to my employer or do I not disclose to my employer, comes up. And I think it comes back to questions about whether the MS and the symptoms of it impact on your work capacity, and if so, how. Having said that, there's no formal requirements that you must disclose. But if you don't disclose your MS to your employer when you're asked, and the symptoms lead to some kind of workplace accident, which may otherwise have been compensable under the work cover scheme, it's possible that you won't be entitled to those work cover entitlements. It's also possible that you could have some kind of liability for consequences of the accident or the injury if others are impacted. I think that's unlikely, but I think it is possible, and it's something you should consider carefully. So the other question that we're often asked outside of disclosure and those requirements is about modifying work. This slide talks a little bit about part-time or other modifications. And generally speaking, the general position is that the employer has to make reasonable changes to your employment to accommodate your illness. So if you do disclose the illness and you do so in the context of needing to work part-time or needing to work from home, that's a common one now, or needing to not do certain aspects of your role, then if those things can be accommodated by the employer, then they have to be accommodated by the employer. And that's a bit of a grey area sometimes. The lines between what can and can't be done may be different from employer or an employee perspective. I like to use an example of a lady that we helped years ago, and we ultimately helped her with a TPD claim. But her history is that prior to ceasing work due to illness, due to her MS, she was a school teacher. And it's a good occupation to speak about because we all know what school teachers do, because everyone's been to school, whereas not everyone's been a plumber. She ultimately was diagnosed with MS. She had a relapse early on, and her symptoms were relatively minor, fortunately for her, in the outset. Now, it's easy for me to say that they were relatively minor. They're relatively minor in the scheme of the MS spectrum. She had some optic neuritis, and she had some difficulty seeing, particularly at night. Otherwise, she had only a few relapses. Her disease was otherwise well controlled, and so the only real accommodation that, and some fatigue as well, and no doubt pain, but she wasn't very forthcoming with those types of details. So the only real requirement that she had is that she didn't want to work full-time hours post-diagnosis, and also she had difficulty driving at night because of her vision issues, and she needed to be be excused from parent-teacher interviews and also after-hours staff meetings and functions and whatnot. And so her employer, which was a large school in a suburban area, they were able to accommodate those restrictions because there were other teachers that could teach for her. So she was able to split her class 3 and 2 days per week between her and another teacher. And the fact that she had a second teacher in her classroom, a primary school environment, meant that that other teacher could do the parent-teacher interviews and the function. So in that scenario, her employer was able to accommodate her illness and the symptoms associated with her illness, and therefore she was able to have those modifications in place. But the question of whether or not modifications can be made and whether the required changes can be had is really a question of what are the inherent requirements of the job. So this slide talks about, can I go part-time or modify my work, in more detail? And effectively, it's about whether or not it's reasonable for the employer to make the changes that were needed. So if we go back to our school teacher example, what we see there is it was a big school environment, and so therefore the changes that were needed could be accommodated. However, if you were to flip that scenario up and make it a hypothetical where the teacher was teaching in a very small school, I spent time when I was younger at going to a school that had just 2 classrooms, and the kids split between those 2, and so there were 2 teachers and a principal. In that environment, I think it would be quite difficult to accommodate the restrictions, unless you were able to bring someone in who, in a way to accommodate the fact of attending functions after hours and things like that. So it might be a bit harder in a smaller work environment, which is often what we see. We also, perhaps if we were to think about someone that's diagnosed with MS and works in a manual role in perhaps a hot environment, and if they're heat sensitive, but their job involves them working on the council and having to be outside in the summer months, it might be quite difficult for those restrictions around that illness to be accommodated to allow them to stay cool in the summer months. So typically, the bigger the organisation, the more likely they are to be able to accommodate the restrictions which are required. All of this hinges on the inherent requirements of the job. So in other words, if you can't do the important duties of your job, your employer may be able to say that your employment is frustrated and terminate you. And this may be a scenario that arises out of you not attending work for a period of time or refusing to do certain aspects of your role. And if your employer was looking to move and terminate you in the context of you not attending work or refusing to do some aspects of your role, they would really need to prove that the things that you were refusing to do were important duties. They were inherent requirements. They weren't peripheral rather to the requirements of the role. Similarly, they would need to prove that they wouldn't be able to find some other way of getting those things done. So again, back to our teacher, in her scenario, her restrictions were work part-time due to fatigue and not attend after hours meetings and parent-teacher interviews. And it was quite easy to plonk another teacher in alongside her, split the class in that way, and have that other teacher attend those after-hour duties. But we talk about a smaller school, may not be possible with the budget of the school to bring in another teacher to work alongside her. It may be that that increases the cost of employing the teachers. It may be, and therefore that's not possible. But in our larger school, the teacher that's working part-time alongside our client perhaps works full-time and on the other days works in a different classroom or in a different role within the school. So generally, larger scale organisations are better able to accommodate these changes. But if, again, importantly, if the employer wants to move and terminate rather than accommodate, then they need to prove that their inherent requirements. So in other words, if you are looking to challenge an employer's termination on the inherent requirements point or the important duties point, I think ultimately there would need to be some setting out of what the important duties are, which is normally the easy bit. And then the harder part is comment on whether you can do them safely. And that'll often require some support for your doctors. So conversations with your doctors about whether or not you can do the duties that are agreed are in the role. Use our position description, our employment contract to determine those things, and then get the doctor to comment on whether those things can be done safely. I think another good example may be in an MS context where we're dealing with someone who works in a reasonably hazardous environment. Perhaps they're in a construction environment, or there may be a boilermaker who welds and has cognitive limitations. And so often times we see disputes with employers around the employer saying it's not safe for this person to be in this hot work environment or this construction environment where there are cranes and other dangerous activities going on due to cognitive issues. The individual employee saying that those cognitive issues do not jeopardize their performance in the workplace, and then getting doctors to comment on that. And doctors can be nervous to make those comments sometimes for fear of liability, but I think it's important to have those close relationships with the doctors and get those certifications if needed. If we do have a situation where an employer maintains that the important duties or the inherent requirements of a job can't be done, then what we're looking at is we're looking at an unfair dismissal claim. We're looking at the employee saying that there is no basis for the dismissal, or the dismissal ought not happen because the inherent requirements can be completed, or similarly, or rather the inherent requirements can't be done, but the modifications required for that person to do the work can be accommodated, and we can have some pretty messy fights around that. Unfair dismissal is a whole thing, and I'm not going to go into too much detail about how it works. There's some information on the screen about it. Fair Work Australia provides a lot of resources around it, and we get tangled up in ideas around discrimination, which I'm going to discuss in a moment as well. Ultimately, I think it's really important for people to understand that you have 21 days to appeal a termination of your employment in most cases. Our statute of limitations in most areas of the world that we work in from a lawyer perspective is 6 years. But for an unfair dismissal perspective, it's going to be 21 days. So you do have to move quickly if your employment's terminated. And the remedies that you'd be looking for would be kind of like some kind of compensation for being terminated, or reinstatement of your employment if the employment relationship's not untenable. Again, we'd be looking at whether or not, one, you can do the inherent requirements of your job, as opposed to the employer saying you can't, or number two, whether or not if you can't do the inherent requirements, modifications can be reasonably put in place. And those are the two main areas that people battle it out with their employer over. So the next main point that we talk about when we're talking about employment and MS is discrimination. So when I start out talking to you today about having conversations with your employer and whether or not that ought not be happening, then that's your best place to get a feel for how that will go with your employer, how HR will if you have indeed if you have HR, how they will react to requests for changes, the diagnosis itself, and these types of things. Now, the protection that you do have when you disclose, or if you decide to disclose that you have MS, is that under the relevant laws, you can't be dismissed simply because you have MS. And I think that's an important point to understand. I will say, as I've already said, you can be dismissed because you have symptoms associated with your MS, which mean that you can't work. But the fact of you being diagnosed with MS is something that can't be the basis of a termination. So employers would be very careful in that scenario. If they were looking to dismiss, they'd be very careful to make sure that they've gone through and considered the inherent requirements and the modification points I've already laboured earlier. So I just hope that that distinction is clear. So just like you can't fire someone or not hire someone because they are a female, because they may be black or from you know, some other country, or that those are reasons. Race, gender, disability are all areas that are protected, and you can't discriminate against somebody on those bases. However, you can perhaps terminate someone because they can't do their job, and that's not considered to be discrimination. That's the distinction that I'm trying to draw out. But I will say that you can indirectly discriminate against someone. So whilst you can't discriminate against someone, you can't treat them differently simply because they have MS. If the effect of a policy or procedure at your workplace is such that you are discriminated against because of a symptom of your MS, then that's what we call indirect discrimination. So in other words, if your employer has a policy whereby all staff must attend the office at least one day a week on a specified day to facilitate an all staff meeting, which for reasons that I won't sort of make up on the spot can't be facilitated online, then that would be discrimination for you, but it would be what we call indirect discrimination if you can't get there. Similarly, if your workplace has a policy whereby all staff must have a driver's license because they do outreach work and you're required to drive on your own at certain times, then that would be considered indirect discrimination. You would be discriminated against. The effect of the policy is that you can't do that job. So that is a type of discrimination because of your MS, but it's indirect discrimination. You are not being signaled out because of your MS. It's an indirect outcome of the particular policy or procedure which leads to you being treated differently because of disability. So that would also apply to you applying for a job and being rejected for the job. The employer couldn't reject you because of MS, but they could reject you if one of the symptoms of your MS was that you couldn't drive. That would be a valid reason not to hire you, and not necessarily discrimination, or not legally actionable discrimination. So you have some protection in the forms of discrimination laws, but if it ultimately does eventuate that because of your illness, because of the disease and the symptoms of it, you do sadly have to cease work before retirement age, you should consider whether or not you have insurance that you can claim on. The insurance that we're talking about is normally total and permanent disability or income protection insurance benefits. And that can be insurance that you go and apply for directly through a broker or planner or to the insurer directly. Or it can be insurance that's provided to you through your superannuation, or it can be insurance that you get as a result of your employment. You can have these protections in place. So if ultimately you can't continue to work, or you're terminated in circumstances which you may be able to challenge but you decide not to, or ultimately you can't challenge it, it's a valid termination of your employment on the grounds of disability, then you should think about claiming on these disability insurance benefits which you have. They can provide much needed income, support you, support your family, make sure that you've got an ongoing income that you can survive on. I will say though that we talk about the interaction between insurance and unfair dismissal action. So we often have clients come to us in circumstances where they have been dismissed from their employment and they're looking or seeking to take action against their employer from an unfair dismissal point of view. In other words, they don't agree that they can't do the important duties of their occupation, or they think that there should be reasonable accommodations made to allow them to keep working. If you were to take that action further with Fair Work within 21 days, that time when I spoke to, then the evidence or the submissions that you make in bringing that application can have an impact on income protection and TPD benefits now or in the future. What I mean is effectively you're fronting up to the Commission, to the Fair Work Australia, and saying, I can work, or I ought not have been terminated because I can continue to work in a reduced capacity. And that can sometimes be incompatible with later saying to an insurance company, I had to stop working on this date because I was totally and permanently unable to do my work again. So making submissions in support of being able to continue to be employed can later have implications for income protection and TPD claims. And so we would recommend that you seek advice before taking those actions, just to make sure that if ultimately you do have to claim any insurance benefits, you've got the benefit of not having disclosed too much in that application that's going to be adverse to your insurance claim. So if you are looking for that type of advice around super and insurance, or you're wanting to discuss an employment matter in the aftermath, we recommend that you do get legal advice. If you do get in touch, we can give you help, or we can give you some advice around employment very briefly, as I mentioned earlier, and we can refer you out to an employment lawyer. Similarly, the MS Plus people will have people that you can speak to. If you're wanting advice around super and insurance, we can definitely help. Details on the screen. Once again, my name's Tom Cobbin, solicitor at Beryl and Watson, and more than happy to speak to you and give you any guidance in the future should you require it. Thank you for listening.